Good morning, everyone. Welcome to the Housing and Services Committee meeting. We are going to take up H 582, which is an act relating to adult protective services. And we're going to have first a walkthrough by Ledge Counsel, Jen Carby, and then we have a host of witnesses. And welcome, Jen. It's nice to see you.
It's nice to be here.
And too.
Why have you been such a stranger?
And busy in other places.
I bet you're still working, huh?
Yes, in fact, I'll be in between here and a couple of other committees this morning, so I may be in and out.
Oh, good.
So good morning, Jen Carby from the Office of Legislative Counsel. And I think what we are looking for at 582 is actually a strike all amendment in order to incorporate a couple of additional changes from the Department of Disabilities, Aging and Independent Living. So I think that the idea was just to start with that version, which is largely the same as introduced.
And we have members, this is on our webpage.
So this is H 582, an act relating to adult protective services. And it has several sections in this same chapter in Title 33. So we start off with the definition section. There's a very long list of definitions in the chapter on protections for vulnerable adults. And this would really overhaul the definition of neglect. I think this definition was added, or a version of it just recently in some work that Katie did in this committee. And so this would change from the definition that's in here now to some new language saying that definition means the failure, so that's on page 2, the failure of a caregiver, agent, or fiduciary to provide the goods or services that are necessary to maintain the health or safety or both of a vulnerable adult. It continues to specify that neglect does not include self-neglect, and then it gives some additional clarifications on what is not considered neglect. So the actions or inactions of a caregiver or fiduciary, which is a defined term you'll see in a moment, shall not be considered neglect if the caregiver or fiduciary is acting pursuant to the wishes of the vulnerable adult or at the vulnerable adult's direction or vulnerable adult's representative's direction and authority, or in accordance with the terms of a vulnerable adult's advance directive. So it's not neglect if the caregiver or fiduciary is following the direction of somebody who is authorized to provide direction. Report, which is a term that is used a lot in this chapter for statements from a reporter alleging that a vulnerable adult has been abused, neglected, or exploited. This is just taking out that necessarily means statements provided to the Adult Protective Services unit. I think Dale will explain to you the rationale for all of these provisions. I'm just telling you what's here.
Thank you.
A reporter continues to be the person who submitted a report to Adult Protective Services, but also this bill creates an opportunity for someone to submit a report to a licensing entity. So you'll see that coming up in, I think, the next section. Representative under existing law is a court-appointed guardian, agent acting under an advance directive, or agent under a power of attorney, unless otherwise specified in the terms of the power of attorney. This is taking out the reference to executed pursuant to Chapter 18 VSA Chapter 231, because you'll see in the new language in new definition 35, this just gives a definition for advance directive. It has the whole meaning. As in 18 VSA 9701, which has its own whole process for executing an advance directive, who can do it, what can be in it, etc. We have a definition of fiduciary. So that is an individual or entity who has a legal responsibility to make decisions on behalf of and for the benefit of another individual and to act in good faith and with fairness. And that term includes a trustee, guardian, conservator, executor, agent under a power of attorney, or an advance directive, or a representative payee. Section 2 amends 33 VSA Section 6904. This is on the nature and content of a report of suspected abuse or neglect of a vulnerable adult. And so it starts out by giving a carve out from the traditional process. So except as otherwise provided for certain reports of neglect in subsection B, which we'll look at next, the report goes to the Commissioner of Dale or the Commissioner's designee, and it sets out the requirements for what has to go into the report. And then the new subsection B here on page 5 says if neglect is alleged to have been perpetrated within a facility that is licensed by the state or a program licensed by the state, or to have been perpetrated by an individual licensed by the state, the report should go to the relevant licensing entity as follows. And if it's neglect within a licensed facility or program, that should go to the applicable state licensing unit in accordance with state and federal licensing rules and regulations. So if it's, for example, licensed by Dale, it would go to Dale. If it was licensed by the Department of Health, it would go to the Department of Health, et cetera. If it's neglect by an individual licensed by the Office of Professional Regulation, that should be reported to that office. And neglect by an individual licensed by the Board of Medical Practice should be reported to that board. If a licensing entity identifies neglect allegedly perpetrated within a licensed program, facility or program, or by a licensed individual, so if the licensing entity then identifies that there is neglect, they should make a report to Adult Protective Services. Section 3 amends provisions around assessment and investigation of these reports. And under existing law, the investigation provision says within 30 calendar days after the date of notice advising that a report has been substantiated, the perpetrator may apply to the Human Services Board for relief on the grounds that the report is unsubstantiated. It requires the Human Services Board to hold a fair hearing. This would add language specifying that that must be within 60 calendar days after the date of the alleged perpetrator's request for a fair hearing. It would strike existing language about priority, putting in a different priority. So priority under this bill would be given to appeals in which there are immediate employment consequences for the person appealing the decision, and would require the hearing officer's written findings and recommendation to be issued within 15 calendar days after the hearing. Finally, the act would take effect on October 1st of this year. And that is the language.
Thank you, John. So page 5B, my bias up front before I even ask the question, I don't like this. Yeah, first of all, is it possible, staying within what the federal, for us to have a piece that says that the neglect that's being reported first to these folks shall also be copied to licensing and protection, even if they're not the ones doing the investigation, so they're aware of it in case they end up feeling like, I mean, I worried about it not being an independent process. You know, that like, I don't mean this would happen, but just as an example, the medical board feels like, we know what doctors are supposed to be doing, and we think this standard is too high for a doctor. So we're going to say it's not neglect. And there's nobody outside the doctors who would say that's not right.
Yeah, I'm not aware of any reason you couldn't have language in here that is, you know, instead of sort of waiting to see if the licensing entity identifies neglect, to have it, you know, immediately reported to both places. Or to have sort of a no wrong door approach as well.
Right. I would assume, I mean, we assume for fiscal reasons, we would not want to say both would be investigating at once.
Right.
But at least if the report goes to APS so that they're
I'm not aware of any issue with it. Dale can, and you know, he's hearing the question and can speak to that.
That'll be my proposal.
I would say I was struck by the same thing, that there's some mechanism for dual reporting, maybe clarifying who will be acting to substantiate or not. And the other body can choose to do what they would like after. Related to this, and maybe this is the first time I'm seeing this, so I apologize, but Human Services Board would be the appeal option. even if something is referred to the Board of Medical Practice?
So I think even if something is reported to the Board of Medical Practice, Board of Medical Practice may take its own action, but they would also then be reporting to Adult Protective Services, which then I think would do their typical process.
Okay.
But I think you may want to get some more clarity from the department on what they envision. We can make the language sort of a little more specific about what happens, who goes where, when.
Yeah.
I think you're right that if the Board of Medical Practice were to initiate disciplinary action against one of their licensees as a result of this activity, that appeal would not go to the Human Services Board.
Yeah. Okay, yeah, and
But
that,
if something that flows through Dale would.
so I guess some clarity for that, I guess, just hopefully. Additional question, back to the top, neglect. And when something is not neglect, page 2,
See here, line 15.
yeah. So line 17, it's not neglect if it's pursuant to the wishes of the vulnerable adult. To me, what comes to mind is capacity issues of the vulnerable adult. If I'm caring for someone in my home, my wife, and she instructs me to do something but doesn't necessarily have the capacity, it's like, you know, don't feed me anymore. But she is, I don't know, has some condition that her capacity is in question. Can I really just follow the wishes of someone who doesn't have capacity and not feed them anymore? I'm not sure I'm being as clear as I would like, but there seems something missing there.
Yeah, and I think it'll be important to hear from the departments what their thoughts were on putting that language in there. I know even in our, except for limited exceptions in the advanced directive context, typically whatever the individual is expressing as their wishes are to be followed. But
So would Vermont law, in that instance, have me go to a court to try to make a determination as to the person's capacity and whether I can be acting on their behalf, and therefore we wouldn't necessarily follow that?
I don't know. I think it's a good question for the department, so
Okay. Thank you.
invite them to address.
Any other questions for Jen? Okay, great. Thank you so much, Jen. We'll listen for a while. Okay, thank you. Sorry, I'm John and Joe. I don't know if there's another chair up there, but Representative Nielsen is not here, so you can use that chair if you would like.
Thank you. The big one chair.
Representative Steady, I'll be going down with you. Okay.
Thank you.
Thank you for saying, I'm already, yeah.
Oh, thank you.
Welcome.
Thank you.
Welcome back.
Thank you very much. I'm Joe Nussbaum. I'm the Director of Dale's Division of Licensing and Protection.
John Gordon, the Director of Adult Protective Services.
And I want to thank the committee for inviting us to testify in support of H582. So we just went through the particulars and the walkthrough and the exact changes. I wanted to start by talking about broadly the two chief things that these changes accomplish. The first is, which I would say is the main event of all of this, is updating the definition of neglect to bring it in compliance with federal rules. And I think it was mentioned in walkthrough that the neglect definition that's there was replaced in 2023 when we were last year, which is not accurate. That actually the definition was discussed for updating at that time, but it actually it tracks back to the original statute, which is now, I think, over half a century old. Is that correct? So this does update it for the first time. It's not something that happened in the last pass. The reason for updating it is how neglect is defined nationally in practice in other states, pretty much across the board, and federally has evolved over time. And the most concrete evolution of that was the new federal rule, which came into effect about a year after the new APS statute was passed in May of 2024. So that new rule, it requires that a level of negligence be considered in the definition of neglect, and we can get into that, but essentially this new definition that's proposed does meet that. And John and I did confirm that by going down to DC, Washington, DC in August of 2024. We met with the Department of Health and Human Services, who we were able to ask directly, like, Vermont has these different levels where we specify neglect. Does this meet the national rule? And we got a very resounding confirmation that no, it does not, that neglect shouldn't have levels of consciousness. You should just be looking at the effect. And it's sort of an all or nothing. We get a certain amount of funding from the feds, and it funds one FTE essentially, which in our small operations is pretty essential, field presence. So if the entire rule is not followed, you lose 100% of that federal funding. And they're going to start looking this fall of 2026, to see that states are in compliance with the rule. So
I think that this is, it's just interesting because I remember vividly how the committee labored over the definition of
I
neglect.
was thinking the same thing when we.
Yes, I mean, I don't know how many hours we
Hours.
spent on the definition of neglect, and then just to see it all struck out was kind of like a stab to the heart, to be honest. But I appreciate the, hearing the rationale and the need, and sometimes simpler is better. I don't know if that will be the case here, but I remember having this very conversation that you just brought up about, well, what if it wasn't intentional when, and,
exactly.
so we tried to thread that needle, but, okay. Yeah,
And there's all of our work.
I know, like lost out.
Timing is everything, right?
Yeah.
Yeah. So we have this federal rule. We have obviously a very big motivation to be in alignment with it. Is actually required that states are, even those, the money is the only punitive action taken if not. But Dale was also very conscious from our efforts in 2023 that there was contingency, particularly in the healthcare community, that was very concerned about going to a more strict liability definition, this federal rule definition. And so Dale, and I'll go into this in a little more detail. Good. I'll go into it in a little bit about how we arrived at a consensus, but the main takeaway there is we did arrive at a compromise, which is the language that you saw and walked through earlier, and that both meets a lot of the concerns of the stakeholder groups that we met with and brings us in alignment with the federal rule. So that's the first thing that this bill accomplishes. The second one, which is not as exciting, but it was a very essential nonetheless. It's a timeframe correction. The appeals timeframe, the way that it was written, and I think it might have just been an oversight that wasn't caught, is it started a 30-day clock from when the individual recommended for substantiation would have to appeal to the Human Services Board. And it was also written that the Human Services Board had 30 days to issue a decision from the start of when the individual is notified of their substantiation. The hearing, yes,
hearing.
sorry, thank you. So, so the hearing,
So that's essentially the same time frame.
yes, they could run out the clock to 30 days and then, and especially because the Human Services Board only meets once a month. If those things don't align, it just wasn't viable. So it makes a correction for that. This probably had 1/100th of the discussion of the rest of it because it was not a controversial element. I think the biggest discussion was around the timeframes, but the 60-day timeframe and the 15 days to issue a decision, those were both agreed upon by everyone in the stakeholder group that convened around this over the last year. So I wanted to just take a moment to talk about that stakeholder process and the compromise. I think it's noteworthy to go into. In talking to Dale Commissioner, Dr. Jill Bone yesterday, She had hoped to be here and really for the sole purpose of expressing her gratitude of that group that came together, and I echo that. We started meeting on this, and at the start of meeting, it seemed like we were in very antithetical places. We had a healthcare community that recognized that changing the definition and requiring reporting of neglect to APS at a different level could have a really chilling effect on an already strained workforce. It could also erode the community of trust that the healthcare community has been working on for years to be able to report these things without punitive measures. So very real concerns there. And then, of course, Dale's concerns chiefly always are protecting vulnerable adults and seeing that they're adequately protected and certainly should be protected from caregiver negligence. So starting from that, it was very hard to see where we could arrive at. We met 15 times last calendar year, and there were 16 stakeholder groups that were part of that cohort. And in the work that we did arrive at a compromise where what we came up with was an alternative reporting channel so that the reports that reporters already had to report to, for example, it was brought up earlier about the Licensing and Protection Survey and Certification Unit as the licensing entity. They do already through CMS have the strict liability definition of neglect, and those cases of neglect need to be reported there. So it was agreed upon that these reports would be shared across entities and give APS the authority to investigate negligence. So it's in its purview, but it doesn't have that chilling effect of having the workforce be required to report directly to APS. And again, yep.
Can I ask a question?
Sure.
So, I guess I don't understand the chilling effect of, you're getting reported to licensing and protection, or you're getting reported to APS, or you're getting reported to OPR. I mean, it's going to be chilling all the way around. So I don't really get that. But I think it makes some sense to be reporting to entities that already have oversight over, whether it's a particular profession or a particular like licensing. So I guess one of the things that maybe you can add to your comments or remark on is how will you ensure communication happens? So like between OPR, for instance, if there's a healthcare professional that comes under, a complaint because of neglect to OPR, how will that information be shared so that you can make a decision about whether you're going to investigate it or not?
Yes. Great question. So I'll start by pointing out that there was a later change to change implementation from immediate to October 1st of this year. And that is to give time to put the MOUs in place and the education efforts in place so that everyone's aware that this is a new statutory requirement with this information sharing. It also will educate the workforce that these reports will be shared amongst these entities, and all of the entities that would be part of this report sharing agreement were part of the working group, and we're aligned with seeing that this happened. So there's the desire, and I can speak myself. The most common one that I envision happening would be to the state Dale's Division Licensing and Protection Survey and Certification Unit, and as the DL director of both APS and SNC, I would by that example of setting up and making sure that those reports are shared across the programs.
So for, I'm thinking of the healthcare professional, thinking of a skilled nursing facility, let's say, that where that needs to be reported to survey and certification. But if it's being done by if the allegation is that, it was a nurse or a doctor or, some other healthcare professional that's covered by the Office of Professional Regulation, so it's still going to have to report in two places for some of these facilities. Is that right?
It can be. So one of the big takeaways as well was there was an agreement that there's no wrong door, that yes, there may be instances where something falls under both and there's still requirements to both, and they would have that. But APS certainly, even though it may not be required to report directly to APS would not accept a report or send it out to be referred back. That would And does that answer your question?
No.
No, you're asking,
No, so a skilled nursing facility that is covered under licensing and protection,
mhm,
and also has healthcare professionals covered under OPR.
yes,
And let's just say the allegation was against a healthcare professional covered by OPR. The facility would then be obligated to report in both places. Is that accurate, I guess, as I'm asking? Yeah,
That is accurate because we don't control the reporting requirements of, say, S&C or OPR. We can say theoretically, if this were to pass, we would say, okay, APS's reporting requirements can go through one of these channels,
yeah,
but it wouldn't change the reporting requirements that they have to those entities.
to those other entities. And so, I'm just, in an instance, let's just say that, that the facility reports it to licensing and protection, and they fail to report it to OPR. Maybe, I don't know, for whatever reason. Is there any, I guess I wouldn't want there to be an issue for the facility if they, took what they thought was the right thing, but didn't really realize that they also had to go this other method.
so this aside, we already do make those referrals.
Okay.
So that's already happened.
Already happened.
So sort of leveraging what exists.
Okay. Okay, that's helpful. Thank you.
So I did provide to Lori in testimony, I provided, if you care to see a breakout of all the stakeholder groups. I'll add a note to this that I really think everyone in these 16 stakeholder entities really did participate in almost all of the meetings. Like everybody showed up. It was a very active working group. There was talking through a lot of different scenarios and getting us out of situations. So again, I just want to shed a light on the good faith measure that everybody was there and their patience to really hear and understand the concerns of all parties and arrive at this compromise that we landed on. Also included in what I sent to Lori are some flow charts, so you can see both the existing path and the proposed paths of reporting. They're pretty basic. I mean, in the first, you have a bifurcated to APS and then the other required entity, and then alternatives where you can go to an entity that then makes the referrals. And apart from that, I want to just conclude with my statements. We'll get to some of the questions that came up in walkthrough, but the four main takeaways are that this change does bring Vermont into compliance with the APS federal rule. It does preserve that by effectively doing that. It preserves the funding for APS that comes from the feds. It clarifies that unworkable procedural timeframe for appeals to the Human Services Board. And I think, probably the biggest victory in this is it reflects the consensus solution that this group came together and worked over the last year at arriving at, which we're very happy and grateful for. So.
All right. Other questions from the committee? Yeah, go ahead.
Just if I can get some additional clarity, I'm still a little confused on the questions asked by Madam Chair.
Yes.
So get the statutes actually. So if a nurse if they're regulated by OPR, if there's some question about neglect, were you saying that the report would come to APS and you would make sure it got to OPR, or am I reading it correctly? The statute requires.
It would go to OPR. The requirement would be for it to go to OPR and OPR would share it with APS. So that would be a statutorily required path.
Okay.
An optional path would be to report directly to APS. APS could take the report and act independently. Or if it went to the survey and certification licensing entity, say, it would go to both OPR and APS.
Okay. So are you what's referred to here as a licensing unit?
The Division of Licensing and Protection is APS. Within that is not.
Okay. Is there any need, as we look at the definition, it talks about the report shall be made to the relevant licensing entity as follows. Is that actually a plural, entities, that it should be sort of simultaneously reported? That's top of page 5. Lines 3 and 4. Bless you. Sorry, I'm being a little dense on this one, just trying to understand it.
Well, I mean, they can choose more than one. So relevant doesn't have to mean one, even though it says entity.
So you said they can choose, so it's
I
not
mean, when I say
Required.
choose, it's required,
required.
whatever they're required to do, but I'm saying that, so the applicable state, that's the example that I was giving,
Yeah.
so. So a nursing home with a nurse, let's just say that there's an allegation against, they would, report that to the Division of Licensing and Protection, which is the other half of the witnesses, division. And they would then also report it to OPR.
So it's okay, I'll pause a moment. I did write down some questions from walkthrough, but John, did you want to add anything or does that cover?
I wanted to comment on what the chair and vice chair mentioned before about the work that was done in this committee, because a lot of work was done on this definition. And the definition as it left this committee was actually would have met the requirements of the federal, but it was the work in the Senate and the compromise that came out of it to allow the bill to move forward. So I just want to acknowledge that there was a lot of work done and
Not for naught.
Yeah.
that was just the open comment that I want to make, and then we probably move on to the questions.
Just make sure when this moves downstairs, you mention that. Okay.
You said it, I was.
Thank you, John. I appreciate that.
Yeah.
Good. Are there any other questions for these witnesses? Do you want to ask the question when you're talking about the?
Well, I don't know.
I
if
did
you were
make a
getting to
couple
that.
of notes,
I think
yes,
City made
so-
some notes in response to.
Okay.
Sure. So one of the things came up was your question about appeals to the Human Services Board and what if there's concurrent, if I understood it correctly, concurrently an appeal to the Medical Examiner's Board. The HSB hearing is only applies to the registry placement, to the adult abuse registry from APS's findings. So any other appeal to medical examiners or other entity would
Had to do with license or anything like that would not go to the Human Services.
Right. Only for that registry placement. The other question was around neglect and the question around neglect and capacity. I would say the biggest philosophical change that happened to the APS statute in 2023, definitely the most important, was making it victim-centered and putting the victim's rights. Prior to that, there were very few appeal rights. There was no deference given to the direction or wishes of vulnerable adults. So you'll see that language brought in wherever possible to be considered. That said, if capacity is not there, APS won't just defer to the vulnerable adults' wishes in that instance. Gale itself does not determine capacity. We rely on medical professionals or some other source to determine that, but those things are balanced, but they're both there for that reason.
And just a comment on that language that talks about deferring to the rep or the alleged victim. That language was in the previous statute. So that language is actually brought forward. That's not new. It may look new because it had to be rewritten.
Yeah.
Struck down and rewritten, but the content of that language is actually been it's been quite a while.
It's all new to me.
I just wanted to make sure that it's clear that that's not a new.
It's not a new concept. Yes. Thank you, John.
I'm just thinking through the example I gave. If I'm caring for my wife and something happens with her capacity, she's, says, well, don't feed me anymore. And if I have a question, I guess I would have to go through proper channels, court, whatnot, to contest capacity if that's what's causing her statements to me about whether she wants to be fed, in my example.
Right. APS would not act contrary to that without some other entity, medically diagnosing or weighing in, correct?
In order to provide care against a person's wishes, that's a pretty high bar.
Yeah.
So
Okay.
this is really, does APS, like, what do we take the position on is maltreatment? Is a little bit, if a person is trying to do the best they can, provide care, and the person they're saying, no, I don't want it, and they really feel that they need it, if they were to give that care, that'd be providing care without consent, against the person's wishes. So that's a whole, like, you're almost in a position where you could be going the other way. So the capacity is very much like, it's a very thorny issue. And most of the cases that get very thorny have a capacity element that we're trying to suss out. And there's a lot of those cases that end up in front of the courts to help suss that out.
Thank you. Thank you both.
Yes.
Commissioner Bowen, you were referenced here just a few minutes ago.
And then you appeared.
And then you appeared. I know, it's kind of like Nolan does for us, but you're welcome to make a few comments if you would like.
Yeah, well, you may have made those comments, but I really just want to shout out the sales division of licensing, which APS, Adult Protective Services, is a part. And the really extraordinary work that went on this past year with 16 different stakeholder interested party groups across the board. And they are listed in the testimony. But it is, advocacy groups, medical groups, and legal groups. Really, everybody you can imagine who would have a concern or an interest in this work. And we really reset the kind of the playing field on this by acknowledging that all parties are of critical importance in this work. That's the vulnerable individual whose safety is paramount, and the caregiver or workforce community whose well-being is critically important. And the 15 meetings that occurred were very collaborative. We had facilitation in most of them, and really worked through almost in a way of creating a model of how to come to consensus and stay in compliance with CMS. And just a shout out to the two gentlemen you see right up here at the front, and to all of the members of this collaborative work group. See Helen on the screen, that really came together to bring this to a very different place here.
Thank you. And thank you for bringing the work forward. I want to just ask one thing that isn't maybe quite obvious from the examples that you gave in your testimony and the sort of little diagrams that you included, because it all references facilities, and a lot of these complaints actually don't come from facilities. I guess so the survey and certification part really would be not applicable. So it would then just go to APS.
Correct.
Okay. Just want to make sure, because you didn't give any example for that.
Right.
And-
It's not discussed. But
I think it's because that's not really a change.
Right.
Yeah. I just wanted to make sure that the committee
Yeah.
understands that. So any other questions for these witnesses? It's nice to see you both here again.
Here,
Thank you. And thank you for your work on this.
very much.
Okay. Helen.
Yes, thank you.
Morning.
Good morning. I'm having some internet connectivity issues. So with your permission, I'm probably going to keep my video off just to make sure that I do not freeze on the screen.
Okay, well, you have a lovely picture.
Yes, forgive the impromptu advertisement for Storyworks headshots.
Yeah.
So my name is Helen Laban. I'm the executive director of the Vermont Healthcare Association. We represent nursing homes, assisted living residences, and residential care homes in Vermont. And I'm speaking sort of for the group of different providers who were part of this, as has been described, fairly intensive process of coming into compliance with federal changes around that neglect definition. A lot of what I could say about the process, I think, has already been said. Many meetings, many stakeholders, and also a shared acknowledgement that in spite of the work and thought that Vermont had put into our definition, it was no longer in compliance with the federal requirements, and we did need to change to this new definition. I think that one way, and this is, I will also add, a very, although it's a somewhat straightforward change in the definition because it was different from the sort of the conceptual framework that Vermont had been working from, it caused a lot of legal review, reviewing regulations, reviewing policies. It got pretty complicated pretty quickly. A way to, I think, simplify the change as far as the statute is concerned, and sort of as the provider groups looked at this, was to think about the class of neglect concerns that are newly brought into investigation for this change. So we were looking primarily at those instances where the neglect had been unintentional. Perhaps the individual had no ability to have done otherwise, basic errors due to the imperfection of the world. And additionally, on top of that, with the look at the licensed facilities and licensed professions, remember, we are under an obligation to report all errors where something has gone wrong in some significant way. So we aren't necessarily looking at an outside allegation of neglect, but rather a self-reported incident from, in my case, a facility. I'll speak primarily to my members who are licensed facilities. And when we look at those instances, we have, lots of examples of what might happen. Sort of a common one would be, say, in a nursing home, there's a transfer back and forth from hospital, something goes wrong with the medication reconciliation. The receiving nurse doesn't receive the full medication list and a medication is missed. So in that instance, something has gone wrong and should be investigated, and we should figure out what went wrong, but it needs to be looked at in a sort of holistic, system-based way to understand where the errors occurred. It wasn't necessarily the fault of that individual nurse who received an incorrect list and therefore missed a medication. And we can think of other examples. There's a weather event, there's a call out, a nursing home is understaffed, and LNA does not respond promptly to a call light because of the understaffing. Is that individual LNA's fault, or was there something else that went wrong with the staffing? Similarly, for onboarding and training, we can think of many different examples where the error is more organizational than an individual's error. And when we look at those instances, again, something went wrong, should be investigated, should be corrected. But the investigating entity that's set up to do that sort of evaluation would be, in our case, survey and certification, not necessarily APS, which is set up more for an individual fault situation. And so we wanted to ensure that those reviews went to the regulatory entity that had the infrastructure in place to deal with organizational errors or systemic errors, both out of fairness for the individual, but also simply from the desire to make the appropriate correction. And so hence you see the referral pathways that try to ensure that the entity that is best set up with those situations is the one that does the initial investigation. And then the other element behind this is also looking at the timeliness of those investigations. Because remember, if an individual has been reported and is under investigation, they're not working during that time. And so that is both a problem for staffing and also for that individual who is not working for what could be an extended period of time. So we had a desire both to have the appropriate investigations and also to have timely investigations for the best interests of all involved. And you see there the language that we agreed to accomplish that. Additionally to the questions, and I think this has already been addressed, of who sees what reports. does DLP have the ability to review all reports and ensure that everything is happening as it should be? No wrong door was brought up many times, and this is where the lawyers came in. So, in full honesty, I deferred to the legal review of how those pathways were established, and trust to the review that is in fact accomplished through this new language. And then additionally, we had conversations about the need to do lots of education for providers and for individuals on this change, on this complicated change, and hence setting a deadline that would accommodate that and also meet the federal requirements. So we feel good that it was a complicated and involved process, but that we reached a place that everybody could work with to the best interests of everyone involved in this process.
Thank you. Thank you, Helen. Are there questions for this witness? It looks like you're clear, Helen.
Great. Thank you so
Thank
much.
you. Thank you very much. And I saw Kylie walk in. Hi, good morning.
Hello, my name is Kylie Kuiper. I'm the State Long-Term Care Ombudsman at Vermont Legal Aid. And I have just short comments on this. We think that this change is important and beneficial for Vermonters. It's really difficult to prove intent in situations like this. So just to say, if the needed services are not being provided, that's a problem. We think that's an important change to protect Vermonters. As many of you flagged, we do think the language around reporting is confusing, but the overall change is something that we strongly support.
Thank you. Questions for this witness? Okay, so far we're holding true to the, this looks like people are in agreement.
If you'd like, I could respond to the concerns about competency. And
Sure.
so we had more concerns based on the complaints that we get about people being forced to get care that they are saying they don't want, and that not being respected because someone says, well, I'll be, I could be accused of neglect if I don't make you do this. I don't make you take this drug or something. So that's a much bigger concern than we have. There's a different question of what a worker can provide to someone who is saying they don't want it. But this statute is about what a worker can be basically punished for not providing. And I don't have concerns about the language as far as that if someone is saying, I don't want this and a worker doesn't provide it, that the worker wouldn't be found liable, basically.
Does that help make sense?
Yeah.
Okay, thank you. Thank you very much, Kylie. Appreciate it. Okay, so it appears as though nobody asked any additional questions here.
Other than when you were out.
When I was out?
You want to.
Yeah, your concern was.
Yeah.
Because there was, yeah.
Okay.
So it was purely the issue of the reporting, the way that if it's the professional or the medical society, or if it's, it goes to them. And that potentially would bypass an independent oversight component. And the suggestion was to simply that it be copied to the Department of Licensing and Protection. Not that they do a double investigation and so forth, but it simply be, they receive a copy, so they're aware of the fact that complaint has been made.
So that was kind of the issue that I was following up on, not knowing that was a question. What I heard the division say is that the reason that they changed the effective date to October 1st is that they would be implementing MOUs between the organizations. Did I hear that correctly? Yeah.
So I missed, picking up on how that might.
Yeah, and I think
Address
that would
that
address that. issue.
Yeah.
And I think it's really important to have those because I think,
But just
The only thing is, we've had this in other areas. I mean, MOUs can totally address a problem, but they're not required to be maintained. Things can change down the
Mhm.
line.
Mhm.
And then it would force, okay, then it has to come back to the legislation, make an amendment if it's not happening. And if
So-
it's just in there, then, or if it says there shall be MOUs, then we know it's in there and we don't have to worry about some future time.
So are you suggesting at the top of page 5, that if neglect is alleged to have been perpetrated within a facility, blah, 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 the report should be made to the relevant licensing entity as follows. And maybe the addition of a,
Can I invite myself?
oh, it says number 2. Number 2 says it shall be, make a report to Adult Protective Services.
Can I
Yes.
sit and make, so
That's,
Jen Harvey, Legislative Counsel. So my suggestion that I think maybe would address the concern, is if we split number 2 into 2 pieces. And we said, hold on, I'll put the language up again. Putting it the right one, yes. If we were to say something like, if a licensing entity receives a report of neglect allegedly perpetrated in the facility program, blah, 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 the licensing entity shall inform Adult Protective Services, and then that would be like A, and then B, if the licensing entity identifies neglect, then they would make a report to Adult Protective Services.
That would-
Does that seem like it? Want to see if that works for,
Does that sound all right to people in the room?
try not to make it too.
John's going like, John's, I'm not sure. It just essentially says that you get a copy. I mean, that's,
The only question I would have is, do I have a requirement with that information?
no,
This is awareness.
it's just awareness, right? I don't think that language would in any way. Because right above it, it says who actually investigates. So.
Yes.
Outside.
no. So, the, do you see an issue with that, Jen? Does that create a duty on the part of APS once they've received a copy of something?
I mean, I think it comes down to a little bit of a distinction between a report and a sort of,
Notification.
Yeah, so I can see where the question is coming up, looking at just the regular language about reports to be made. And then it kind of kickstarts the process. So I think we could say something like shall inform, but, APS doesn't have to take any action unless there's a follow-up saying we have found.
Unless that part 2.
Yeah, I mean, I guess I would maybe want some clarification from APS about when they would want to act if they're made aware of something. Because it seems like with this new language, there's sort of the regular report to APS, and then there's a separate report to the licensing entity. And aside from being made aware that the licensing entity has received something, is there ever a point before the licensing entity does whatever it does with that information that APS wants to be doing its own investigations?
So I wonder if it just.
Maybe we could just say they can coordinate as appropriate or
So
something.
chooses shall provide advice or consultation. I mean, if APS chooses. because-
Yeah, I feel
don't
like
think
you're, I don't think we really need to do
Yeah,
that.
yeah.
I think that, not Helen, Jen, if we can, maybe concentrate on that, notice part, essentially notifying APS that they've received and are acting upon a complaint. That's an FYI from my
Mhm.
perspective.
Mhm.
So I think along the lines that you were talking about.
I'm fine with that.
Okay,
The MOUs will take care of the
The details.
The
about what it
details
is.
of how all that
Yeah.
interacts.
Let's just make
We
sure
just
that-
have that.
Yeah. Okay. Anything else? That was markup, people, just so you know. This bill's gonna move quickly, we're trying, it's less than 6 work days to cross over, so. Jen, is there any chance, because we have a couple of members who are not gonna be here tomorrow, is there any chance we could have this back today?
Yes.
Awesome. Okay. Anybody have any other questions? Committee members? Okay, thank you very much. Thanks, Jen, appreciate that, and just let us know when you have it back, and we're gonna squeeze in the vote today. I think that's the first time since I've been here that we've had a review of the bill and testimony, markup, and vote. Okay, thank you all. Take care. Okay, so we have a little bit of time, but let's take a brief break till 10:15, and then we'll be back online, and we're going to take up H 657 this afternoon, but I'd like to have some committee discussion about 657, and Anne's got a bit of an update about the sections that she's been working on, so we'll do that after we have a brief